Hey, everybody. Here again, happy to be there. I'm estate planning attorney, Paul Rabelais. Who inherits in Louisiana when there's no will? Let me tell you a little bit about me, then we'll jump right in to the subject matter of these intestate laws in Louisiana. So I've been an estate planning attorney in Louisiana, helping people since 1991, more than 33 years now, probably enough to say I have a little bit of experience. And so, yeah, I've helped thousands of people. I own a law firm that helps people all around the country and all the states, but I'm going to focus really mainly on Louisiana. Every state has their own rules on who inherits from you if you live in a particular state and you don't have a focus on the Louisiana. I've been dealing with this for 33 years. It's an important topic because you can look up something like 50% of adults in America have. Here, let me get some. I can do a couple of things real quick. And here we go. Okay, we're good. All right. So important, about 50% of the people out there, of adults in America, don't have a will. So as you might imagine, it happens all the time. People die with having done no estate planning. And I get it. It's a topic that people procrastinate on. We do like to see the people plan, be proactive, make sure you take care of the loved ones that you have, make it easy for them. So there are a lot of people who have done the planning, millions of people out there, but occasionally, not occasionally, more than occasionally, people die and they've done nothing. All right, so let's jump in. I'm going to try to keep this as layman's terms as we can. I'm going to try to cut out as much of the legal gobbledygook, cut out as much of the legal mumbo jumbo as I can, and try to keep this where the ordinary person can understand it, even though I'm going to use some terms that you've probably never heard of before, like a term in Louisiana called Usufruct that I'll get to in a minute. Okay, so when somebody dies and they are domiciled or they lived in Louisiana and they didn't have a will. Now, just to complicate things a little further, sometimes people pass away and they don't have a will, but they have an IRA with beneficiaries, designated beneficiaries. That IRA will be payable to the designated beneficiaries. The will or absence of a will has nothing to do insofar as where that person's IRA goes, because an IRA has beneficiaries. Life insurance policies, annuities typically have beneficiaries. So we always look to the beneficiaries first. But here in Louisiana, typically own things like real estate. Lots of other things that you can't put a beneficiary on: vehicles, brokerage accounts, and stocks and bonds, and so all that stuff that passes pursuant to the intestate rules. If you die without a will, if you have a will, then Louisiana law deems that you died testate with a last will and testament, and of course, the terms of that last will and testament dictate who inherits from you. But you had no will, you died intestate. Who gets your stuff? Well, the answer, of course, it depends, and it depends on several factors. And I'm going to go through those factors, as we move along here, start with maybe the most common example and work our way through it. I'm going to keep out the really crazy stuff and focus on the scenarios that we see most of the time. Okay, most of the scenario that we see most of the time, although there's a couple of close seconds and thirds here, but I'd say the one we probably need to start with is when a married person with children dies without a will. Okay, so that's common. Someone gets married, they have one or more children. So that's the typical traditional family. And that married person dies without a will. Who gets their stuff? Then maybe they have a house and a few bank accounts and some CDs. They may own some stock. They may own a business. They may own an LLC, vehicles. Who inherits from them? I think a lot of people think that stuff just, automatically goes to the surviving spouse. Hey, this couple bought a house together 15 years ago, and the husband just state rules in Louisiana. I'd say, this is me just generally speaking, they really favor the descendants of that married person, the children, the grandchildren. They really favor the descendants of the married person more so than the intestate laws favor a surviving spouse. So things just don't go to the surviving spouse when the first spouse dies. Now, like I said before, if the husband owned an IRA, could be $100,000, could be $1 million, could be a $10 million IRA, and he named his wife as his designated beneficiary, then yes, because the beneficiary designation controls, then when the husband dies, that IRA is going to go into the wife's name. And so the intestate rules have nothing to do with that. The intestate rules have everything to do with all of the other assets. Let's get right into it. Married person dies. Let's call it the husband dies. Most men think they're going to die first. Husband dies, leaves a surviving wife, and let's say 2 children. Real common example. And let's just say it's 2 children of the one marriage. Again, another common example. So here's the deal: in a state or without a will. Well, Louisiana is a community property state. So assuming they had no prenup and, assuming they, maybe the husband was 65 years old, he got married to his wife when he was 25. Like he would have told me if he came in to do some planning, he would have said, Paul, we didn't have a pot to what in when we got married when we were 25. And so everything we have, we acquired it during the marriage. It's community property. So Louisiana is a community property, which really means what the husband and wife have is community property, meaning it's owned 50-50, half by the husband, half by the wife. Yes, there are some exceptions to the community property rules. Property would have been the separate property of the husband if he acquired it before he got married. See, he died when he was 65, got married when he was 25. So unlikely he had some separate property that he would have acquired before the marriage. That would have been a long time ago. Also separate property if he inherited. A lot of married people have inherited separate property. Maybe the husband's parents died recently and left the husband an inheritance. Well, that inheritance is the separate property as long as he keeps it separate. And so we're not going to assume any separate property for the moment. Also, if there was a gift made only to the husband during the husband's lifetime, that would be his separate property as well. Maybe the husband's uncle gave him $100,000 for some reason. That $100,000 is the separate property of the husband. And, there's the whole, they gave the husband $100,000 5 years ago. Did it retain its separate property status? Because things are in Louisiana that are owned by a spouse are presumed to be community, but you can overcome the presumption. All right, so let's forget all that separate property stuff for now and say that what happens, because what happens is different under the intestate rules regarding what happens to the husband's community property versus what happens to the husband's separate property. So again, the more common type of property that a married person has when they die is community property. Not every time, but most of the time. So what happens to that? All right. So they owned a house and business broker accounts. We talked about it being community property. The husband owns half. The wife continues to own her one half of all of their community property. So if they had a bank account with $100,000, the wife continues to own her one half or $50,000. Now, as to the husband's half of community property, if the husband died without a will, he could have had a will and changed all of these rules, but he didn't. So we have to apply the intestate rules. As to the husband's half of the community property, his surviving spouse, or in this case, his wife, inherits a usufruct. Usufruct, probably a word you've never heard of before, but it's a unique form of ownership that we have really only in Louisiana. So $100,000 bank account, wife continues to own her $50,000, the husband's $50,000, the wife inherits a usufruct over the husband's or the decedent's share of the community property. And we'll get into usufruct in a minute, but this usufruct terminates or ends when that surviving spouse either dies or remarries, whichever occurs first. We'll talk about that more in a minute. And anytime someone is left a usufruct or someone inherits a usufruct, there are also what's called naked owners. So that ownership gets divided up into usufruct, which the surviving spouse inherits, and naked ownership, which the husband's children inherit. So look at it more broadly. And again, you got to break it down asset by asset. But if the husband and wife had $1 million of assets, very generally speaking here, Wife continues to own her $50,000. Husband died intestate, $500,000. Husband died intestate. Husband's wife inherits the usufruct of his $500,000, and husband's children owners who become the full owner of the estate first. That's when her usufruct terminates. Okay, that's a mouthful. You can go back and listen to it again if you need to. You can even slow it down on YouTube. So since this is so common, because it's very common, people don't have wills and they are married and they have kids, and the surviving spouse inherits the usufruct of the deceased spouse's one half of the community property. Let's talk about what over two types of assets. There's a usufruct over consumable assets, and there's a usufruct of non-consumable assets. So now we got to break it down. If husband and wife had $1 million in assets, we got to look at what those assets are to determine the rights that that surviving wife has as the usufructuary until she dies or remarries. Let's talk about how she may have inherited the usufruct of consumable things. Consumable things are those that can't be used without being expended or consumed or without their substance being changed, such as the most popular type of consumable item is money. And by money, I really mean cash. And by cash, yes, I do mean green dollar bills, but I also mean checking accounts and savings accounts and certificates of deposit and brokerage account, money market accounts. I mean, that's cash. And so that's a consumable item. Money is a consumable item. There are other kinds of consumable items that we don't deal with as much. Harvested agricultural products, what's called stocks of merchandise, foodstuffs, and beverages. But so let's talk about what happens if husband, where of their $1 million of assets, $100,000 of that was a bank account, and that's a consumable item. And husband died without a will, and so wife keeps owning her $50,000 to do what she wants to with. But what about husband's $50,000? That's a consumable item. What rights does she have? So if the things subject to the usufruct are consumables, which it is, she gets the usufruct of $50,000 of cash. The usufructuary, in this case, the surviving wife, becomes the owner of the consumable items. And as the statute says, that surviving wife may consume, alienate, or encumber them as she sees fit. But at the termination of the usufruct, that wife is bound either to pay to the naked owner the value that the things had at the commencement of the usufruct, or to deliver to him things of the same quantity and quality. What does all that mean? It means that when the husband dies and the husband intestate without a will, and the husband and wife had a bank account with $100,000 in it, the wife has $50,000 to do whatever she wants to with, but she's inheriting the usufruct of his $50,000. She becomes the owner of his $50,000. However, at the termination of the usufruct, which, as we said before, when she either dies or remarries, whichever occurs first, that's when she owes the children of the husband. They're the naked owners. At the termination of her usufruct, she owes the children of the husband the $50,000 that she had the usufruct of. All right. So and then always, people start asking lots of questions. Well, what if she invests that money and it grows to $200,000? Well, she got the usufruct. She became the owner and she can do what she wants to with it. But because it's a usufruct of a consumable, when she dies or remarries, she or her estate owes his children $50,000, even if she turned it into the $200,000. The question that I get more often is, well, what if she spends all of that money? And so answer is when she dies, she spent that $50,000 that she had the usufruct. When she dies, her usufruct terminates, and it's a debt of her estate. So to the extent there's any assets in her estate, husband's naked owners get the first $50,000 in her estate before any of her heirs get anything. But what if nothing's there? Then nothing's there, and there's nothing for husband's naked owners to collect. So there's, lots of times a spouse will die and then the surviving spouse will die many years later, and we have to do all of these usufructuary accountings. It can be difficult. All right, so we just talked about what happens when a surviving spouse inherits the usufruct of a consumable item. Now let's talk about what happens when the surviving spouse inherits, again, because the first spouse to die died intestate without a will. What happens when the surviving spouse inherits a usufruct of a non-consumable item? What is a non-consumable item? Those are things that may be enjoyed without alteration of their substance, although their substance may be diminished or deteriorated naturally by time or by the use to which they are applied, such as lands, houses, shares of stock, animals, furniture, and vehicles. So I would comment of non-consumable item that we deal with when a married person dies, or when for what the surviving spouse did with the assets which they had usufruct. Very common ones are real estate, like a home, and shares of stock, like shares of ExxonMobil stock. So let's talk about that. So we just talked about the rule when a surviving spouse has usufruct of consumables. Now we'll talk about what happens when a surviving spouse inherits a usufruct of a non-consumable item under the intestate rule. So let me give you an example. Let's say the husband and wife had a home, and that home is worth $500,000, and the husband died without a will, and that home is community property. Well, the wife continues to own her undivided 1/2 interest in that home, and she inherits the usufruct of the husband's 1/2 interest in the home. So now she's inheriting a non-consumable item. So let's talk about what happens in the future. Let's say she just lives in that home for the next 10 years. It appreciates from $500,000 to $800,000, and she dies 10 years after he did. Well, because she had the usufruct of a non-consumable item and it never got disposed of, then his heirs own half of the home, and half of the home is in her estate to go to her heirs. So where it was a usufruct of cash, how much cash was a really important number to have when the first spouse dies. With non-consumables, it's different. And maybe another example is shares of stock. People get confused about this with the number of shares, community property, all of that. So let's say a husband and wife owned 1,000 shares of ExxonMobil stock. Even if perhaps the stock account was in the husband's name, how that account is titled is not the ultimate determination of who owns that account. If purchased during the marriage, then with community property, then even if that stock account is in the husband's name with 1,000 shares in it, it's community property. And so what happens is the wife will continue to own her 1/2 or her 500 shares of ExxonMobil stock. Now the husband had 500 shares of ExxonMobil stock and he died intestate. So his wife inherits the usufruct of his 500 shares until she dies or remarries. So if she never sells that stock, then when she dies in the future, his children will get the 500 shares that he had when he died, and then she can do whatever she wants to with her 500 shares, including probably leave that to the same children, but she'd have the ability to leave that to whoever she wanted to. All right. So, and again, regardless of whether the stock appreciates or depreciates, because it's a non-consumable item, when the surviving spouse dies, the husband's children just get the stock because it was a non-consumable item. Now, the trickier thing is, let's say that stock is sold 5 years after the husband died. And when the husband died, their 1,000 shares of stock was valued at $50 per share. And now, a few years after husband dies, wife is able to sell that stock, that all 1,000 shares of stock, for $100 a share. Well, now the usufruct of a non-consumable item, shares of stock, got converted to a usufruct of a consumable item, cash. And on the moment that stock is sold, the proceed, the wife becomes the owner of those proceeds. She can do what she wants to with it, but at the termination of the usufruct, she owes the husband's children the amount of the proceeds of the sale when she converted that non-consumable to a consumable. Okay, so it's a mouthful there. Feel free to listen to it or watch it more than once or twice. Hey, Chelsea in the chat. Good to see you. See your name just about every time. Rendon Income Tax. Does Louisiana have transfer on transfer on dead deeds? I think you're trying to say transfer on death deeds. But to answer your question, no. Louisiana does not have transfer on death deeds. That's why you see so many different pieces of real estate going through probate, because there is no way to keep that stuff out of probate like you can in other state real estate to a limited liability company or LLC. There is no way to provide for people to kind of automatically or be a beneficiary of your LLC when you pass away. The ownership of that LLC must go through probate when you pass away, if that LLC was in your name when you pass away. Now, again, all these rules that I'm talking about there, what happens if you die without a will? So there's a couple of things that people do to eliminate these problems or these issues that surface when somebody dies without a will. One of the things people do is they write a will. So you can change and get around all these. If you're like, I don't like all of that. I want to leave my stuff a different way to different people, the way I'd want to do it. Well, then you can write a will to do it. And some people even take it a next step. A lot of people take it a next step, which is transfer what they have to their revocable living trust and have their trust designate who inherits from the trust when they die. And then when they created their trust and transferred assets to their trust, assets that are in your trust when you die, they avoid that court and attorney involved, what other states call probate, what Louisiana calls succession. Assets in a trust avoid the cost and delay and hassle that is involved when you die with assets in your name and your survivors have to go through the court and attorney involved succession process. Assets in a trust, avoid that. That's typically called a living trust or revocable living trust. Main reason there, eliminate the need for the survivors to have to go through that court process. Okay, so we talked about how so far married couple with children or married person with children who has community property. This is kind of the most common scenario. They pass away with some community property. Of course, surviving spouse continues to own their half of the community property. Surviving spouse inherits the usufruct of the decedent's half of the community property until the surviving spouse either dies or remarries, whichever comes first. And at that point, the first spouse to die's children become full owners of those assets. Now, another, I mentioned earlier, our intestate laws really favor the descendants more so than they do the surviving spouse. If a married person does have some separate property, let's say in our situation, the husband and wife, we talked about how they had $1 million of community property, but let's say, a couple of years before husband died, he inherited $1 million from his mother or his father or whoever. So they have $1 million of community property and husband has $1 million of separate property. If the husband died intestate, which is if the husband died without a will, again, the husband could change this by writing a will and doing all kinds of planning. Well, his separate property, his surviving wife inherits no interest in that at all. The husband's separate property goes straight down to the kids. So wife inherits usufruct of his one half of the community property, but wife does not inherit his separate property. It goes straight down to the kids. So that's why it becomes important to determine when a married person dies, what is community property, what is separate property. And again, there's rules for doing that. But and it gets tricky when community property gets mixed up with separate property. Then it gets real tricky in determining what's community and what's separate, because it makes a difference on who is inheriting and who can benefit from all of that. All right, so let me shift to a couple of other scenarios, maybe not as common, but they do happen. So obviously this one happens a lot. Somebody dies, they're not married, and they have children. Well, it happens all the time, because in my previous example, married couple with children, we talked about the husband perhaps died first, and now the wife inherits the usufruct of his one half of the community property. Well, if that surviving wife or any unmarried person with children dies, their stuff just goes straight to their children. Again, if that surviving wife does has the usufruct of the husband's half, then those assets that she has the usufruct of will go back to the husband's children when the wife dies. But all of the wife's assets, she's single, she's not married. All she has is separate property because she's not married. So an unmarried person can't have community property. Yeah, they may have some assets that were community property when their predeceased spouse was alive, but an unmarried person really only has separate property. It just goes straight to the children. And when I say it goes straight to the children, sometimes children predecease their parent, or sometimes children die before their parent. So when that's the case, under our intestate rules, if a parent dies and things are going to the children, and let's say one share, the deceased child's share would go on down to the deceased child's children. We call that representation here in Louisiana. It's a unique Louisiana term for that. Okay, and then someone asked me today, Paul, is that the same thing as per stirpes? And yes, it is. So leaving it to the children, but if a child predeceases with children, then the deceased child's share goes down to the deceased child's children. But if the deceased child did not have descendants, then the deceased child's share would go to the other children. So there's all those what ifs, and I don't want to go too deep into all of those what ifs, but you get the point. All right. Yes, Texas has it, and we do a lot of work for Texas at our law firm. We've got lawyers who's licensed in Texas, and have been talking to a lot of Texas people lately in the last few days and helping them. And some were taking advantage of some transfer on death deeds to make things easy for a surviving spouse, and then making sure it goes really to a trust after the surviving spouse dies. You can do that through some transfer on death deed stuff and still keep it out of probate. All right, next let's go to maybe a little bit less common that we see, but still happens in everyday life: married with no children. So let's go back to our example. Married couple had $1 million of community property. Husband also had $1 million of separate property that he had inherited. But let's say the couple has no children and the husband dies intestate. Who inherits his $500,000 of community property, and who inherits his $1 million of separate property? So since he did not have children, a little bit different rules. His surviving wife doesn't inherit the usufruct of his community property. She inherits ownership of his one half of the community property. So they had $1 million of community property. She keeps her half. She inherits ownership, not just usufruct, ownership of his half of the community property. But his $1 million of separate property, she'd like to get it, but she's not going to get it. So again, if the husband didn't have children and he died with $1 million or any amount of separate property, then the husband's brothers and sisters, or if they're predeceased, their descendants, inherit husband's separate property, subject to a usufruct in favor of the husband's surviving parent or parents. So sometimes that happens. Sometimes people die, they don't have any children, they're married, and they have a surviving parent or parents, and they have surviving siblings, and they have separate property. Parents inherit the usufruct. If both parents are alive when that husband dies, that usufruct shall be what's called joint and successive. And if the parent, or if one parent is alive, that parent inherits the usufruct. But if no parents are alive, then the separate property of that husband just goes straight to the siblings of that husband, or if any of those siblings have predeceased, to their descendants. Okay, so again, our Louisiana Intestate Law really doesn't make things super easy for the surviving spouse. You'd think in a case where somebody was married and they didn't have kids and they didn't have a will, you think things would just go to the surviving spouse, but they don't. And there's a lot of surviving spouses who have been very kind of disappointed about that. And then there's been lots of arguments about what's community property and does go to the surviving spouse versus what's separate property and goes to the siblings of the married person who died. Okay, a few areas where people are confused. People do confuse our intestate rules, which is what we've been talking about for the last 30 minutes, with our unique Louisiana forced heirship rules. So let me just touch on that for a second. Our intestate rules are who inherits from you when you have no planning in place. You've never signed a will. You rely on the state law to determine who's going to inherit from you. That's what we've been talking about. Many people confuse the Louisiana's intestate rules with Louisiana's forced heirship rules, which really provide that these forced heirship rules apply when you do write a will, but you exclude certain people from your will. You exclude children of yours that are 23 or younger, or children of yours who are incapacitated at the time of your death. If you try to exclude them, you write a will and try to exclude them, then the forced heirship laws say, no, you can't write a will and exclude those forced heirs. They're automatically entitled to inherit from you. So forced heirs are children. And if you don't have a will, intestate laws apply when you have no will, says who attempt to exclude or significantly limit what a forced heir would inherit. All right, a couple things. How does all this get done after a person dies without a will? Well, let's talk first about the small succession affidavit procedure that we have in Louisiana. If somebody dies without a will and they have less than $125,000 of assets, then the intestate heirs can go through a simpler procedure of preparing some paperwork, preparing a list of assets, signing what's called a small succession affidavit in the presence of a notary, and then presenting that to the bank or the brokerage firm, or recording that in the real estate records of the parish. And it's a way to, when somebody dies with not too much, less than $125,000 estate, it's a simpler way to recognize the rights of those intestate heirs. You don't have to get judges involved. You don't have to get the clerk of court involved. So there's all those delays that sometimes successions take months or years. All that's avoided. It's just filling out some paperwork and having all of the heirs kind of recognize their inheritance rights. And so makes things easier. Now, if someone dies intestate and they have more than $125,000 of assets, and most people do, if they have a home, even if they're married, their home's going to be worth $300,000 and their half is $150,000. And if you add to that, money that they have in a bank, maybe there was $50,000 in the bank, the deceased spouse's half is $25,000. Add those two things together and you throw in a couple of cars, that's likely to cause the intestate deceased person's estate to be more than $125,000. So you have to go through the succession in order to recognize the rights of the intestate heirs. So, every succession is a little bit different based on what assets are there, but generally the way that works is oftentimes an administrator gets appointed by a judge. It might be a surviving spouse. It might be one of the adult children. It could be other people, but that's usually who it is, who will administer things and deal with accounts while this court process is going on. And then ultimately, judges will sign court orders ordering that assets, the ownership of assets, be transferred in accordance with our Louisiana Intestate Law. So very, very common for a married husband to die intestate. And as part of that succession, the wife wants to stay in the home. So the wife could never sell the home until the husband's succession is complete, because the husband's name is still on the title of the home. Can't sell it. Got to get his name off the title. That's what the succession does. And so at the conclusion of the succession, a judge would sign a court order recognizing that the surviving wife still owns one half of the home, that the surviving wife has the usufruct of the deceased spouse's one half of the home until the surviving spouse dies or remarries, and the husband's children are recognized as the naked owners of the home. And again, if the husband died intestate, if she wants to sell the home, she'll have to get the permission of those naked owners. But then at that point, she converted a usufruct of a non-consumable to a consumable. She doesn't have to give the kids the money or half of the money when she sells the home. If she sells the home for $500,000, she owns $250 of it. She has the usufruct of $250 of it. She'll own all $500. But when she dies or remarries, she or her estate owes his kids $250,000, regardless of what she does with the money. Okay, so that's how it gets done when somebody passes away intestate. Chelsea, in New York, a surviving spouse inherits the first $50,000 and one half of the estate of their deceased spouse, and you can't disinherit a surviving spouse. There you go. There's kind of recognizing. Thanks for make that comment, Chelsea. Every state, you got to look. You got to look to each state's rules, and every group of state lawmakers has made their rules, and they often tinker with it from year to year as to who inherits when somebody dies without a will. Thanks for that, Chelsea. Okay, so there you have it. I think that'll do it for now. Lots more to come. We'll see you next time. Take care.